want to begin by thanking the Bar Association here in Franklin County and working with the public schools, working with this college to bring topics of absolute significance and importance to the lives of folks, young folks like yourselves, who can think about what's being presented today and really reflect upon the messages that you're going to hear. It's not like one particular item will be the one takeaway, but it's accumulative. Something somebody says you're going to be thinking about for a while, that reflective process is going to be important. So I want to thank the Bar Association for that and the Planning Committee for picking, I think, a very important and significant topic for your lives. I want to just end my little piece by sharing with you the same thing I share with my 19-year-old daughter. With regard to all of the topics of today and the use of social media and the use of technology. By the way, she's off in college, and people ask us how is the empty nest, and I tell folks it's not an empty nest, it's a full text. So you think about what that means. The advice that I give to my 19-year-old is the following: one, be smart. The stuff that you put online, the information that you're going to put out for public, and it is public, will be there with you forever. I know you've heard that message many, many times, but that is what we talk about in our home. The second thing we talk about is be respectful. The community that gets developed on social media really is about not just communication one way or the other, it's about building community. So I ask my daughter to think about how respectful she needs to be online in the same way that we talk about being respectful to each other when we're talking face to face. So with that, I'm going to, I guess, turn it over to Dave, who will come up and just also say a few words of welcome. Thank you very much for coming here. Take the time to appreciate your community college. Welcome, everybody.
Good morning, everyone. I want to welcome all the students from the various schools in Franklin County and their teachers who took the day to come and join us. Also to the members of the Bar who are present and members of the GCC community who are attending. My name is Dave DeHert. I'm the current president of the Franklin County Bar Association. And Law Day is an event we put on every year in partnership with JCC and the Northwestern District Attorney's Office. There are some special people who I'd like to thank for their contributions to ensure that this event went off without a hitch, hopefully. One of the things that we do every year at the Bar Association is we set up a couple of committees. The Law Day Committee, the members of the Bar, this year for that committee were Leah Phillips, Isaac Mass, John Connor, myself, Don Gallagher, and Yana McClure, and also a part of that committee was Christine Bronis, who is the executive director of the Franklin Bar Association. It was that committee's duty to basically choose a theme for this year. This year we chose the theme of social media and the decline of privacy rights. It's something that we believed was very current and present in everybody's lives nowadays. I remember the days when there weren't computers. That kind of dates me. And when there weren't cellular phones, or there were, but they were this big. And so you had to kind of strap them to you as you walked around. But nowadays, it's like it's everywhere. Everywhere you look, there are tablets, there are iPhones, there are Samsung Galaxies, there are all sorts of devices, and people are constantly networking with each other. So we decided that it's time, I think, to really take a look at how the new technology impacts the rights that we have, or the rights we perceive we have in the society. Now, as part of this Law Day event, we'll also be awarding 2 scholarships from the Thomas W. Merrigan Scholarship Fund. That scholarship is funded by some events that the Bar Association has every year, a trivia event, which Dorothy Starro is very significant in putting forward. That's when we get to see a lot of lawyers, judges, and court officials show us how much useless information we all know. and how much trivia we can all pull out of our interfaces at our ages. Sometimes the stuff is whirling around, it's difficult to pull out. But the money that is raised from that event goes to the scholarship fund. We also have a tennis tournament every year, which is a Tri-County Open, where the 3 counties, anyone can enter it. And myself and attorney Byron Capeless put that on every year, and we play that down at Deerfield Academy during the summer. It'll be June 22nd this year. So if you're tennis players, a flyer will go out. Just go to our website, and if you're interested in playing, last year we had 2 high school students from New Hampshire win both the singles and doubles. So it's not necessarily the oldest that do the bestest in that tournament. But, and also the individual donations that we get from our members and members of the community to fund this scholarship. Right. Just a little bit before we go, I know most people in this room are probably under the age of 20. Social media has been with them all their lives, is when they became conscious of computers and iPhones. But there's a little bit of history that goes with how social media came to be such a presence in our society. In 1969, the only company that was really out there in cyberspace was a company called CompuServe. And the only thing you got when you logged on was this little understrike blinking in the corner of your computer screen. That was it. And you could type in things, but the information you got was not like the information you get today. Anybody know when the first email was sent? 1971. The first email was delivered. In 1981, the first personal computer hit the market. It was a Radio Shack model. It was called the TRS-80. It had a favorite nickname called the Trash 80 because of how often it crashed. And it used to be 1 unit, you set it on your desk, and you basically use it for typing. In 1989, the British engineer Thomas Berners-Lee began work at CERN. It was a European organization for nuclear research in Switzerland on what became known as the World Wide Web. In 1992, Tripod opened as a community online for college students and young adults. In 1993, CERN donated the www technology for the world to use. That was before social media. In 1997 was when blogging first began. That's not too long ago. And AOL Instant Messaging let users chat. In 1998, Google opened as a major internet search engine, and Friends Reunited was the first online social network to achieve prominence. It was founded in Great Britain to help people find past schoolmates. And in 2001, Wikipedia came to be, and Apple started selling its iPods. In 2002, Friendster was the first social networking website open to the public in the US and grew to 3 million users in 3 months. In 2003, MySpace and LinkedIn began, and Apple introduced the online music service iTunes. That was in 2003. In 2004, Facebook started, and Flickr imaging started. In 2007, Apple released the iPhone, the multimedia and internet smartphone. In 2009, Facebook ranked as the most used social network worldwide with more than 200 million users, and Unfriend was the new Oxford American Dictionary Word of the Year. In 2011, social media was accessible from virtually anywhere and became an integral part of our daily lives with more than 550 million people on Facebook, 65 million tweets through Twitter each day, and 2 billion video views every day on YouTube. LinkedIn had 90 million professional users. In 2012, it was estimated that internet users would double by 2015 to a global total of some 4 billion users, or nearly 60% of the Earth's population. And finally, last year, YouTube topped 1 billion monthly users with 4 billion views per day. Facebook users' total climbed to 1.11 billion. Twitter had 500 million registered users with more than 200 million active, and Apple customers had downloaded more than over 50 billion apps, and the company again improved iTunes, and iPads were beginning to revolutionize the world. I mean, that's basically what brings us here today, because as people start to use social media, social media becomes an extension of our own reputations and our own images. We've all heard of avatars, how people become something else online. Well, with social media, sometimes that happens. And sometimes what it does is it tends to show the world what a person really is about in private. With the scholarship, we had a prompt, and that prompt was basically asking the students who applied to answer the question, what concerns should high school seniors have about access to social media by prospective employers, college admission officers, and the government? Now, we received several applications. All were excellent applications, and so as a scholarship committee, we had to sit down and read all these applications and bring them down to 2. This year we selected 2, one from Turners Falls High School and one from the Academy at Charlemont. The first winner was Sarah McCune, who is a senior at Turners Falls High School. In her career, she's taken 8 AP classes and 6 honor classes. She's a member of the National Honor Society. She has performed a lot of community service with environmental issues. She volunteers for the New England Blue Ocean Society and the Source to Sea Cleanup. And she's also active in the Montague Community Action Group. Her interests include being a student body representative on the Social Community Council member and a member of the Turners Falls High School Gay Straight Alliance, and her interests also focus on social justice issues. The other winner is Noah Jacobson Carroll, who is a senior at the Academy of Charlemont. He maintains a GPA average of 3.75. His community service includes volunteering at community soup kitchens, making a difference day volunteering, assisting local seniors. His interests include he's a founding member of his school's Social Justice Council. He was a representative at the Cornell University Model United Nations. He is a 3-sport athlete. He's a heck of a musician from what I understand and plays a mean bass. And his senior project includes directing a band and recording an album. He intends to attend Haverford College next year. So I'm going to ask Maureen Merrick-Winstick if she can come up to award these scholarships. She's the daughter of Thomas W. Merrick, for whom the scholarship is named.
I would like to take this opportunity on behalf of the Merrigan family, the Thomas W. Merrigan family, to extend our heartfelt appreciation to the Franklin County Bar Association for establishing this honor, the scholarship fund named Thomas W. Merrigan Scholarship. Our dad truly enjoyed the friendships he established with his colleagues on the bar, the bench, the court staff, and the clients he represented. Innocent or guilty, they were always innocent in his heart. He prided himself on treating people fairly. Our dad was an inspiration and role model for so many, and we hope his legacy will continue to inspire recipients of the Thomas W. Merrigan Scholarship Fund. Thank you. Okay, this first scholarship is for Sarah M. McCune, Turners Falls High School. And the second is for Noah Jacobson Carroll, the Academy at Charlemont. Congratulations. Thank you.
Congratulations to Sarah and Noah. Our program today will consist of some short videos. The first one is called 6 Clicks, just to explore the issues that arise with the use of social media. Six clicks, that's all it takes. Find out some interesting things about everyone. At this point, I'd like to ask all of you, because I know a lot of you are on your Facebook account trying to hide some posts at this point, to turn off your electronics before I introduce our next speaker. It's my pleasure to introduce to you now the Northwestern District Attorney David E. Sullivan. David became the District Attorney in our region in November 2010. 2010. He started his law career in 1987 as a civil trial lawyer representing U.S. Army and Air Force service members in general and special court martials in West Germany. He served as a city attorney for East Hampton from 1999 until 2002 when he was elected Register of Probate for Hampshire County, Hampshire Probate and Family Court. As a Register of Probate, David chaired a technology committee and he began the imaging and scanning of filed documents in a system now used in the probate courts, and thank goodness it's there for any attorneys who remember when you used to have to walk in paper and wait for weeks for the paper to come back to you. Now you walk it in, they scan it in, they give you back the original, you're all done. He also helped establish mediation programs to mitigate conflicts between individuals and reduce court costs, and he established a website for the probate court to give the public access to resources and staff. In 2008, he was one of only 2 Massachusetts lawyers chosen to receive the Massachusetts Bar Foundation's President's Award for extraordinary volunteerism, leadership, and commitment to increasing access to justice in Massachusetts. Since David has become district attorney, his office initiatives include creating a domestic violence and sexual assault unit. He created a community outreach and education unit to provide community and educational trainings to strengthening our communities and prevent crime. He co-founded the Veterans Justice Partnership with community and criminal justice partners to provide coordinated services and treatment and rehabilitation and alternatives to incarceration for local veterans and military service members who enter the criminal justice system. His office also established a safe school response team to prevent and promptly address acts of harassment, bullying, and violence that impact students, families, and communities. He helped create a civil rights advisory board to advise and assist his office in the areas of community outreach and education, crime prevention, community prosecution, civic engagement, social justice, and civil rights issues. And he launched the campaign to end sexual assault on campuses, a multimedia educational campaign aimed at increasing awareness and reporting of sexual assaults on campus. David is also a member of the Governor's Council on Domestic Violence and Sexual Assault and a member of the Massachusetts Children's Trust Fund Board of Directors. And when he isn't playing the role of district attorney, he's also been a youth soccer and basketball coach and continues to assist annually with the statewide NBA high school mock trial competition. We've all felt the impact of David's presence in our community, and we thank him for all the good work he and his office are doing. And so at this point, I'd like to introduce to you District Attorney David E. Sullivan.
I've had the opportunity as a district attorney for a little over 3 years to really work in the community, and in particular, I want to kind of emphasize our role in the community. It's really to keep people safe and to make communities safer. But the students here today, my job is to give you the opportunity to really have a healthy and vibrant school experience and to keep you safe, particularly when it comes to the internet. We deal every day with cyberbullying. We deal with sexual predators online. We deal with child pornography. We deal with sexting. We deal with a lot of things that are going to impact you if you get yourself in the wrong situation. And what we really want to emphasize is to really echo what Bob Puro said. Be smart, be respectful, really think of these tools, the social networks that we all have through our smartphones. This is a wonderful tool, but it can also be a tool of destruction for somebody, if it's misused. And particularly, I just want to underline about the most recent epidemic that we have with sexting, and it's going to be talked about today. I just want to say, your reputation, your image, all the words that you put out on the internet really carry a long way, and just think about it. Before you click, just think about where it's going and how it can be used or misused. So again, I just want to say to the students and faculty that are here, thank you so much for being engaged. This is your generation of information. It's your generation of privacy, and you have these privacy rights that were established under the Massachusetts United States Constitution over 200 years ago. And remember, these rights are your rights, and it's yours to hold or give away. And what I can say firmly is that you should really think about how you can preserve your privacy and your right to privacy under the protections that have been established for you. So I want to introduce our panel. Corey Carvalho he's the head of litigation at the University of Mass Student Legal Services, and this Student Legal Services is the premier one in the country, one of the first ones established to represent students at the University of Mass, and that ranges from landlord-tenant rights to also how internet searches take place. So Corey has a Juris Doctorate from Western New England College, and also graduated from University of Mass. So Corey's going to be here today as one of our panelists to give some insight, particularly in how he deals with the internet when students sometimes are caught into that web. It could be because they're charged with a crime over the internet or that their privacy has been violated. So I want to welcome Corey. And our next panelist is Sergeant Mike Hill, and he's a Massachusetts State Trooper, and his specialty is in computer forensic examinations, and he's a former commander of the Internet Crime Against Children Unit, which is the unit that is there to investigate and help prosecute sexual predators that are over the internet. And it's really important that we have people in law enforcement that have the knowledge and experience in computer forensics and can move forward with cases that predators, victimize children with. What's even more important, Sergeant Hill has really been on the forefront of NetSmart and prevention. So the best thing that we can do is to prevent people from being victimized, and he's really been a leader in the state on that. And I just want to thank Sergeant Hill, who's come down from the Berkshire District Attorney's Office and his unit, his State Police Detective Unit today, to join us. So thank you, Sergeant Hill. Our next panelist is Professor Bruce Miller, and Professor Miller has a wonderful reputation in Western Mass for his expertise in constitutional law and really about protecting our rights and the rule of law that we've established in this country, and he's been incredibly effective in fighting for the rights of prisoners held in Guantanamo Bay down in Cuba. He's really been a champion for making sure that our Constitution and the protections that we have protects everybody. So I just want to thank him for the work that he's done on those particular areas. He's also been a member of the board of the Rosenberg Fund for Children, and for those that aren't aware of that, the Rosenbergs were executed back in the 1950s because of charges of treason, and this fund is one that really fights for not just the children of folks that have been put to death by the death penalty provisions in states in different countries, but also to make sure that capital punishment is not part of our culture. So I want to thank Professor Miller. He's been there at Western New England College since 1980, and thank you, Professor, for being here today. Our next panelist is Jamie Wincourt Morrison, and is the owner of Small World. It's a computer and networking company here in the Pioneer Valley. He's a veteran network engineer, and what he's done is really gained an expertise in digital forensic evidence. He's presented in courts around the Commonwealth, and he's been in the information and technology field for over 15 years, and he's going to really lend some expertise on understanding computer networks, and certainly what you saw here this morning is how fragile your privacy really is. If you really start digging, you can really get into some real background on folks. So I just want to thank Jamie for being here today. Thank you. So our moderator here today is Assistant District Attorney Christine Tatro, and she works in our office and has done an incredible job in building a child sexual predator project for us. And what that does is really track sex offenders to make sure that they're held accountable, that they're where they should be and registered within our 2 counties. To really address child pornography and human trafficking and how that really impacts our society, and in particular the victims of human trafficking and child pornography. And she's really gained an expertise in digital forensics. And so when we have prosecutions in our office that involve Facebook, whatever type of social media that was involved in a crime, sometimes cyberbullying, Christine's the one that we look to really give us that expertise on moving forward with a case and deciding whether or not we're going to prosecute that case. So she's a graduate of Elms College and also received a law degree from the University of Connecticut. So I want to welcome Christine up, and she's going to be the moderator for the panel discussion. And again, thank you all for being here today, and it's a real honor to be here at Greenfield Community College with our distinguished panelists.
Sergeant Mike Hill, as you heard, has an expertise in computer forensics, and he uses that expertise as part of the Internet Crimes Against Children Task Force, which is a national task force. He will explain to you what happens and what happens when you put something online, and what your privacy issues are, and hopefully a little bit about how you can protect yourself.
I've been with the state police for over 20 years. With that, I've been conducting internet-based investigations since 1996, 1997, somewhere around there. So I've seen quite a bit out there. More recently, I've been transferred and part of the Internet Crimes Against Children Task Force for Massachusetts, which is a statewide unit. Even though physically I'm in Pittsfield, my jurisdiction or my area of investigations is all across the state. And we see quite a bit of things out there. As for that, everybody keeps talking about privacy rights. Essentially, if you're on the internet and you have at least one friend, I don't care if you are closed off, your privacy settings are set, if you have at least one friend, your privacy rights are pretty much out the window, because I've seen many times where students, friends one day, they post something, whether it's public or private, that posting then becomes something that they can't get rid of. And eventually, it happens, dynamics of friendships, they dissipate, and those dynamics may cause what you posted 6 months ago to get out. I've seen it many, many times. So essentially, your privacy rights are pretty much not there. Just be aware of that, because everything you do comes back, whether it's you're at a high school party one night, friends of you are taking pictures, you may or may not have something in your hand, but being at the party, that gets posted. High schools around where I live, same issue. Many, many times that happens. As for my experiences, I guess most of my experiences I deal with quite a few child exploitation type cases. Most of our case investigations come in through the National Center for Missing and Exploited Children. We average about 1,200 cyber tips a year that deal with some kind of child exploitation. With that, we investigate probably over 1,000 investigations. We rescue children. We give presentations for internet safety. We do a wide range of services as part of the task force. But I got to say, not most of, but a good percentage of the cyber tips that come in usually aren't these types of cyber tips that deal with this type of video that you just saw. Most of them are some kind of victimization for kids your age, whether you're the one that's victimizing, cyberbullying somebody else, or somebody's harassing and cyberbullying you. Um, you know, cell phones are great. I wish everybody can have them, but if you get rid of yours, it makes my life a lot easier. The biggest thing with cell phones is apps. We see it day in, day out with kids actually posting things that they think nothing of it, but it's something that they would post that they wouldn't say, you know, to your face. It's actually better if you say it to somebody's face, because at least it's one-on-one and it goes away. You post something, it stays there forever, and some people just don't realize it. It will be there, whether your friends will see it today, tomorrow, next week, 6 months to a year from now. Your high school, you know, the school officials or whatever may pick up on it. 4 years from now, college applications, they'll pick up on it. And then when you get out to the workforce, I guarantee you your jobs, many jobs, employers out there are now looking and even requesting, you know, access to your, what you would think, private accounts. So there really isn't any privacy out there. And the video at the beginning regarding the 6 clicks, how true that is. Last week I was in St. Louis at a commander's meeting, and we had a representative from Google come in and talk to us about the kind of information they collect and what they can get to us to help with our investigations. And they make it their job to link accounts. And that's just one electronic service provider, Google. So a lot of different electronic service providers are out there linking accounts. They link them by screen names, by email addresses, by cell phone numbers. Everybody most likely submits their cell phone number when they create accounts. So all that is linked. All that will come back to you. If you think you're going to be creating 6, 7 different accounts, chances are within 6 clicks or help with the electronic service providers, we can figure out you know, how those accounts are linked together. And if, you know, we do most of our investigation through social media. We go online and we see what's out there, what people are posting, and that's you. You're out there posting this stuff, so we get a good idea. 5, 10, 15 years ago, we found, or we had a good idea what a person was like by doing a forensic examination of the computer. You know, what they do on their computer, that's pretty much who they are. Now we don't have to do that. We just go online, we do research through social media, and we figure out what kind of person you are and what, you know, who you are. But our biggest hurdle right now is to try to talk some sense into kids your age on what you post and the different applications you're using on your cell phone that are giving us a headache, pretty much.
Can you tell us what some of those apps are that create problems for victims?
Well, some of the apps are difficult because some of the companies that run the apps are out of the country, and it's difficult to get information. So if you become a victim of cyberbullying, or somebody's trying to blackmail you into sending, and it happens all the time, nude photos of yourself, and some people actually do, and to get blackmailed, it's difficult for us to do the investigations and try to figure out who's doing that to you. Other apps that give us a little bit of headache and you think you're secure with it is like Snapchat, where you take a picture of it and it goes out, and the person receives it, and 9, 10 seconds later the picture disappears. Well, there's a ways around that, and some of you probably already know, most of you probably don't, that if you send a Snapchat picture to somebody, they have a way of figuring out how to capture it before it disappears. Now they have it forever, and chances are they're going to use it to blackmail you. And when they post it on certain websites, most of them which are out of the country, there's not much we can do about it, of getting it off the internet, and trying to figure out who actually is the one that's threatening or harassing you. Skype, Kik, Instagram, Pinterest, all these different apps that are out there, is difficult for us to, actually takes up a lot of our time. And if it's just, you know, cyberbullying or harassing, it takes us away from issues such as this last video, where that's a little more important. And it's just, with 1,200 cyber tips a year, it's hard for our unit, which is a unit of 4 people, to get to all of them. So if you can help us out and try to be careful on what you post or who you talk to or the information you divulge out onto the internet, it definitely would make our life and our job easier.
Our next speaker is Professor Bruce Miller, and he's going to be talking about our constitutional privacy rights.
First of all, you know, Dave's introduction of me was wonderfully generous, but I have a confession to make, and that is I am uniquely unqualified to be on this panel. I truly am, and I have a lot of explaining to do for being up here at all. I am an ignoramus and a Luddite. I tend to reject almost all of the new technology. This isn't necessarily out of conviction. It's out of an incompetence that bedevils people my own age. I'm not on Facebook. I do not have a Twitter account. I'm not sure I even know what a Twitter account is. My wife is on Facebook. You know, every once in a while I look over her shoulder and I say, what the hell is this all about, and why are people doing it? I do make Mike Hill's life easier because I do not carry a cell phone. You know, people beg and plead that I start, and so far I have resisted. Now let me, you know, although I have read a text or two, I've never actually done one. My thumbs are too all thumbs to sort of manage it. So far, I haven't been, to my knowledge, burned by any emails I've ever sent, although my guess is that that will happen sooner or later. You know, I wish I could still do my legal research in the books, but we have libraries. We no longer have books because we're supposed to do it all on the internet. So I am forced to, so I do. There it is. So what the hell am I doing here? And I do wonder about that. And I said to Chris Baronis, you know, you want almost anybody except me. And nevertheless, somehow or another, you talked me into this. So what can I possibly offer here? I'm not even sure. Let me try a little bit. Here, let me tell you, first of all, I guess I want to tell you something about, also by way of full and fair disclosure. I have been surveilled by, you know, in a previous time and place, by relatively old technology. When I was a brand new lawyer, would have been roughly 1969, 70, and 71, I was employed by the federal government. I was working for the United States Department of what was then Health, Education, and Welfare, and I was doing civil rights enforcement, mostly. I learned, first through suspicion and later through confirmation, that for most of that time, my work phone was being tapped by the FBI. Now, this was in the waning days of J. Edgar Hoover's tenure as head of the FBI. You know, I was kind of flattered that he was interested in the likes of a puny anonymity like me, but I guess he was. The way I kind of suspected that I was had to do with the relative incompetence of surveillance then as compared to now. And that was that, you know, every fourth or fifth phone call, I would be talking to somebody, and then I would hear either my own voice or the voice of the person that I was speaking with saying again what we had just said 15 or 20 seconds ago. Somebody was doing a playback of a tape that they were making. So I knew that I was being surveilled by someone. And later on, a member of the FBI staff, very, very nice guy, came to my office and wanted to question me, and revealed to me that indeed they had been surveilling my telephone for some months and expected to continue to do so. He wanted me to know that that was going on. And I'll say something in a bit about why that might have been so. So I guess that's some personal experience with what some people might want to call a violation of privacy. For me, figuring out what privacy even is, or why we might value it, or why we might, as Christine suggested, be concerned about surveillance by private companies, by the government, by anybody. Those, I think, remain, for me, open questions. I think they're very important questions. But if, in fact, as Mike suggests, and my experience is similar to yours, I assume I have none. I assume that anything that I disclose to anybody, I am disclosing to the world. I'm wondering if that is indeed true, what is lost by that? That is there anything we ought to be concerned about? The first time I'm aware of that Americans began to focus on something they might call a right of privacy as even an identifiable issue was about 125 years ago. Two Massachusetts lawyers, one of whom, Louis Brandeis, went on to be a justice in the United States Supreme Court, wrote an article called The Right of Privacy. I recommend it, even though it was written in 1890, and you can find it in the Harvard Law Review for that year. They tried to define what privacy might be, and what they said is well, this first definition was kind of circular: intrusion into private affairs. Well, what affairs of ours are private and what aren't? It seems to me the videos have really raised that question starkly for us. And then secondly, and this one I understand, disclosure of facts that a person would prefer remain silent. You know, we all have facts about ourselves that we would, for one reason or another, prefer to remain silent, and I guess I understand that. Well, do we have a right of privacy with respect to those things? Well, Warren and Brandeis tried to argue that we did and that we should. But, and there's a lot of big buts here. Dave Sullivan said what most of us think, and what I think at least ought to be, and that is that our Constitution protects a right of privacy. Our Constitution does not protect a right of privacy, at least in any direct way. To the best of my knowledge, the word privacy never, ever appears in the Constitution. And what the Constitution does do, and look what I'm about to do, I don't want you to think that teachers of constitutional law just always carry a copy of the Constitution in their pocket and to pull out handy-dandy to be at the ready at any minute. So what I want to read to you is the provision of the Constitution that many people believe creates a right of privacy. I am told and have been told over and over again by my wonderful friend and colleague at Western New England, Art Levins, that this does not create a right of privacy. This is the Fourth Amendment in our Bill of Rights. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, no right of privacy, very important protections, but as Art Levins insists, what this is not a protection of some kind of generalized right of privacy, but it is a specific protection against searches and seizures. And searches and seizures of people's persons, houses, papers, and effects. All of those things are things that are property that we all have. And it's, I think, possible that the designers of this provision had in mind the protection of a certain security of property rather than a general protection of a right of privacy. Now, you know, the Constitution, this gets to one of the points you were raising, Christine. The Constitution speaks to our relationship as citizens with our government. Our Constitution does not in any way protect us from other private individuals or private entities. So whatever protection the Fourth Amendment does set up for us against the government applies in no way to searches and seizures that might be undertaken by a private business corporation that wants to know something about us in order to market to us. No protection at all. That protection is going to depend on other sources of law, and there ain't many that provide us with protection there. This constitutional protection is narrower than you might think. The Supreme Court has said in the last couple of generations that searches and seizures under the Fourth Amendment are, whether we have the government doing one, whether the government is doing one or not, depends, and this connects to privacy, on whether we have an expectation of privacy. If the government is searching our affairs in some way, under circumstances where, in the eyes of the Supreme Court, we have an expectation of privacy, then the search is governed by the Fourth Amendment, and the government has to get a warrant based on probable cause in order to do that search. Now, I want to give you an example so that this becomes, I hope, halfway clear and connected with what we're talking about today. This is 1979, the case I'm about to describe, and it's a case from 1979 when the technology was different and not nearly as well developed. Here was the case. You know, it's the kind of a case that Mike Hill could be working on today. Somebody was getting threatening phone calls, anonymous phone calls, over and over again on their home phone. This was way before there was such a thing as caller ID. And she had no idea who was making these calls, but they were very disturbing, as they understandably would. And she went to her local police department and reported it. And the local police department did some investigating. And their investigating brought them to suspect that they thought they might know who was doing it. But they did not believe, I think probably correctly, that they had probable cause to believe that they had targeted the guilty person. And so for that reason did not seek a search warrant, because they didn't think really that they could get one. On the other hand, they did have a next step to take in the investigation, and that was to put something called a pen register on the target's phone, home telephone. And in order to do that, they had to install this pen register. Now, I don't know if you guys know what a pen register is, Mike. My guess is maybe you could say something about what a pen register is.
Just records, like caller ID, records a number that's coming from and basically the time and date.
Yeah, what it does is it records not the content of a telephone conversation, but what it records the number from which a call is made and the number to which a call is made and the date and the time. And given what they already knew, this was the key information that they needed. Was their targeted person making phone calls to the victim of these harassing calls? So they put the pen register without any warrant on the target's phone, and sure enough, it turned out, maybe not surprisingly, that they had the right person. And when the prosecution ensued, The lawyer for the now defendant argued that this was an unreasonable search and seizure in violation of the Fourth Amendment because no warrant on the basis of probable cause had been secured. And what the Supreme Court did with this in 1979 is they said this was not even a search. It was not covered by the Fourth Amendment at all. And the reason why it was not covered by the Fourth Amendment at all is that the target, now the defendant, had no expectation of privacy with respect to that information. Why did he have no expectation of privacy with respect to that information? Because when you make a call, you are voluntarily disclosing to the phone company the fact that you're making a call, and you are voluntarily disclosing to the phone company, well, the number that you're calling. You are giving up the information voluntarily. And when you give up information voluntarily, you are assuming all of the risks of what the phone company might do with that information. And if the phone company is going to give it to the police for investigative purpose without warrant or probable cause, well, so be it. So whatever rights we have under the Constitution to privacy are quite limited by this idea of an expectation. And the notion here is that anything you reveal to anyone, you no longer believe is private. Because if you really thought it was private, you would have kept it to yourself. And that means that what we might think of as private information is not going to be viewed by the courts as private information at all. Disclose to one, disclose to all. That is, I think, the world that we live in now, where I kind of cross paths with this professionally. What I wonder is, what's the problem with all of this, if anything? What are we losing by all of this? One of the themes is, if you haven't done anything wrong, you don't have anything to worry about. That was the first video. Well, you know, who among us, as I guess the Bible says in terms of casting the first stone, who has not done something wrong in this room? I'm not going to ask for a show of hands, but if I did, I wouldn't get any. We all have. And especially when you think about the controversy about what might be wrong. Turns out I was being surveilled because on my own time I was working to try to end the war in Vietnam, which a lot of other people were then too. But it was not a cause favored by the FBI, and they were interested in what I was doing. Our history is that at least when our government has access to information, they will misuse it as often as they use it. That is, they will use it to target people for other reasons who might have done something wrong. Let me close with this, and it's just something to think about. This is something Justice Stevens of the United States Supreme Court said a few years after this Penn Register case. He said, privacy is essential if citizens are to think and act creatively and constructively. He thought that was obvious. Is it?
Our next speaker is going to be Jamie Wynkoop Morrison.
I'd like to talk a little bit about the permanency of the information that you have out there. It's easy for us all up here and down there to say that things that go out, that is, the data that you send is permanent. Not necessarily permanent forever, but it can be very hard to get rid of. Whether it's on your own devices, most of us have 3 devices at least. You have a desktop at home, you might have a laptop, you have a cell phone. Those all carry data and sometimes very personal information. Or if it gets on the internet for different reasons, it can be very hard to get rid of. So let's talk about these. Why is it so difficult to get rid of this data? It might be easier to explain let's say your computer or your laptop or your cell phone. What happens when you erase a file? Well, it goes into the recycle bin, right? That can be pulled out of the recycle bin. Well, let's say that you're more savvy than that. You have a really private financial record that you want to delete, so you hit the delete button, goes to your recycle bin. What do you do next? You empty your recycle bin so somebody else can't go and get it. Is it really gone? It's still not gone. Let's say that this information was so important that you went and you did a quick format of your hard drive and reinstalled your operating system. Do you know that that data can still be recovered, even after all of that? The reason is, and by the way, Mac users, you're not impervious to this. I can still pull data off of your computers too, including cell phones. The reason that this data can still be pulled off even though you thought they deleted it is the way that the file structures are on computers. They work a little bit like a card catalog. Are you familiar with card catalogs still in libraries? Okay, I suspected that.
If only they were still there.
Yeah, absolutely, absolutely. Well, back in the oldie times, let's say, before we had computers that were indexing books in the library, card catalogs would be great big cabinets of index cards that would tell you the title of a book, the author, where to find it, and it would have a number associated with it, with the Dewey Decimal System on it. Well, that's the way that we used to go find books. Data is kept similar to that on a hard drive. In that, let's make an analogy of, let's say I'm a librarian and I find a book in my library that I don't want you to have access to. Okay, so that's like my private file. Let's say it's George Orwell, 1984. And I don't want you to be able to check out George Orwell's book. The easiest thing for me to do, would not to go find the book, would be to go to that card catalog and pull the index out of it. Ha-ha, you can't find that book. Well, for most people, they can't. They're going to go to the card catalog and look for the book, whether they're looking for it in fiction, nonfiction, by the author's name, what have you. They're not going to find it. Well, what happens if I'm walking around the library and I collect all the books together and start going through them? Well, that book's still going to be there, isn't it? Just like your file's there. What happens if I'm really good at the Dewey Decimal System? I also have mastered the layout of this library, and I say, hey, I think I know where this book might be, even if it's not in the card catalog. I can still go up and find it. This is not exactly, but analogous to what happens when you delete a file. All you're doing is you're deleting pointer references to the file. You're basically saying the computer now doesn't really know where that file is located. It's still there. It shuffles it away on your hard drive. It shuffles it away until either you run wiping utilities against your drive, or until your hard drive fills up and it naturally gets rewritten over. It's always there. And you can actually pull deleted data quite easily off of any, whether it's your laptop, your desktop, or even your cell phone. If you mount your cell phone to your computer, you can pull recently deleted things. You can pull old deleted things off it with free utilities. Like there's a utility called Recuva out there. Within seconds, you hit a button, you're pulling old photos, you're pulling old documents, things that you thought were deleted. So what can you do? Well, there is file wiping utilities that wipe the slack space that basically get rid of these files. But do keep in mind that anything you create and anything that you delete can usually be recovered. And again, there is ways to permanently delete it, but that's a bit beyond the scope of what we're talking about today. Because I'd like to move on to why things on the internet that you post can sometimes become, if not permanent, very difficult to get rid of. So basically, what has been shown up here many times over already this morning is that no matter how many friends you have, no matter what social media that you're using, if you're posting something, somebody's on the other end that can collect it. So if you have a photo, if you have a blog, if you have basically any video that you put on there, somebody on the other end could be right-clicking and saving this material. What they're doing with it, well, it doesn't matter. Maybe they're reposting it, maybe they're collecting it, maybe they're saving it for a rainy day when they can go after you for a revenge tactic, let's say. Let's say that something happens that you post and it gets reposted to a website, and your name's associated with it. Well, you guys have heard of the online reputation, right? You have your reputation at school. You have your reputation online. Have you ever Googled your own name? Most people have. Have you seen what kind of information comes up just by Googling your name, especially if you have a less common name on there? You can get things like if you make comments to somebody controversial that's a public figure on Facebook, Google indexes that. So you're using Facebook, you're using your real name, and the comments that you have are indexed there. Somebody takes a photo or blog or a statement that you've made and associates your name with it, it can get indexed. Well, once this happens, let's say that it's somebody that you don't know that's used your material or posted something private of yours, and you really want to get this content off of the internet. Where do you begin? Any ideas? Well, if you know the person, it wouldn't hurt to contact them and ask them to remove it and be very polite about it. What if you don't know the person? Well, that does become a problem, especially with websites that are hosted overseas. As Sergeant Hill was pointing out, that you can go and try to find the webmaster. You can use Whois, for example. There's a website called Whois that indexes, or is supposed to index who owns certain websites, and it should tell you who is registered on the website and how to contact them. It doesn't always work. People do have ways of hiding that information. And even if you turn around and ask that person to remove the content, well, what if they don't? So this is where the whole permanency thing happens, because not only can this information get out and other people posting it and putting it on websites, but the other thing is Google caches websites. Do you know what that means? Did you know that if you have something that you posted, let's say on Facebook, on a public figure, and you find it on the internet, and you don't want your future employer to see it, you don't want your future school to see it, and you delete it, if people search you up on Google, Google is not in real time necessarily. So that information is still going to be there. It's called being cached. It is possible to remove caches. It's a little bit difficult and it takes some time, but even that information is there. So what do you do once your private information gets leaked? And let's say that you can't contact the person that is posting it, and it's really causing you some harm. At this point, the best thing, if you haven't used the best prevention techniques, is to basically bury it. That's another technique that you can do. If you have something out there that you don't want people to see, sometimes you just have to bury it. And by burying it, what I mean is create a positive online presence for yourself. Go out there and use your real name, but without too much information on there. Open up social media accounts, social websites, a blog. Maybe buy your own name as a domain name, and then create an about you that has your interests, your legal non-party interests, but your education, things that you want to reflect on you. If you do enough positive on the internet, it's going to take these Google searches that you don't want. It's going to start putting them on page 2. It'll start putting them on page 3, and it'll eventually start moving them out of the way, so you become this very positive online presence out there when people do a search for your name, rather than people finding out all the negative things that can become quite a consequence when you have employers and other people doing Google searches on you.
Our next speaker is Attorney Corey Carvalho, and he is going to share with us some of his experiences trying to assist students at UMass.
The majority of my clients are 18 to 23-year-olds, which until this morning I thought sort of kept me in touch with your generation. And then I looked at the front of this flyer, and I can only identify 5 of these logos, and so I'm a little concerned. But like many of you, my clients have grown up on social media, use it constantly, and it's become the sort of date and timestamp log of our activities, and a place where we post our most intimate thoughts and behaviors. And as we've heard, it can be a good tool to investigate people and those activities. And what I do at UMass is I represent students in civil cases, that is, where there's a dispute between 2 or more people. And social media has become this sort of treasure trove of information during this dispute resolution process. So if a student comes into my office with a dispute, one of the first things I do about the other party is look at their social media presence. We do what's called this informal discovery, where we'll have our office try to pull as much information about that party off the internet. And you'd be surprised, and maybe you won't be, about how much information is out there. This idea of being 6 clicks away is absolutely true. You may have a private profile. and we may see that, and it may be difficult to get some information from you, but your friend turns out doesn't have a private profile, and there are a lot of pictures of you on your friend's profile, or there's comments you made on your friend's profile. And so that's a very powerful way to get a lot of information from you without any bother whatsoever. But in discovery, we also have this, in litigation, we have this process called discovery, where the parties have to share information about each other. And you're allowed to cast a very wide net. And so if you have a private profile, I can get access to that. The rules of the court say that I can look at that information. You have to turn over all of that private information if it's relevant to my case. And so private very much doesn't mean private. And I believe if you look at the terms and conditions of the websites that you sign up for, all of them say that you have no expectation of privacy when you use those sites. And it's certainly true when we resolve disputes. So what I tell my clients when they come to me is to immediately stop using social media. Don't use any of it while our case is ongoing, because it's very easy to get tripped up. And a photo you post at 2 p.m. seems innocent and benign, but at 11 p.m. it takes on a whole different meaning because of what's happened in the interim. And so it's important to be mindful of what information is out there, and just knowing, if you know that a lot of that information is not private. Perhaps the government may need to take a few extra steps to get there to get that information, but you'd be surprised at how much of it is available. I also see students who are graduating. And one of the first things, they ask me if they're going to go on to law school or a career, they ask me my advice. And my first piece of advice is almost always, will you pass your Google interview? Googling yourself. What is out there? Every employer is going to Google you before making a decision to hire you. So will you pass that interview? I think it's very important to take that step, learn what's out there, because you may have to go in an interview and explain some of that, and it's better to get out ahead of that. One other important area in which I often counsel students, and it's sort of outside of the maybe social media, but it's very much involves sharing of information, and that is using peer-to-peer networks. That is, it used to be Napster, Kazaa, BitTorrent is often used as what I see my students using, to share files, to share mainly music recordings and movie recordings. And I don't know how many of you are aware, but the record industry launched a very aggressive campaign for about 5 years. They began to sue everybody. Everyone who was downloading music, they sued. They sued about 18,000 people, and they sent settlement demand letters to many more thousands. And students came to our office, and we saw hundreds of students who were being sued. And the average settlement offer for a student was about $3,600, which is a tremendous amount of money to anyone, particularly students who have student loan debt and other obligations and very little income. It's a large amount of money, but it turned out to be a very good deal. Because of all of these cases, only 2, as I'm aware of, went to trial. That is, the record industry decided to take this to a jury. And the way the copyright laws are written, the damages, that is the money you have to pay for illegally downloading a song, range from $750 to $150,000 per song, per infringement. The law is not on your side. So if you can do some math, figure out how many songs you have illegally downloaded and multiply that by $150,000, $3,600 is not a bad settlement figure. So of the 2 cases that went to trial in the United States, one was in Minnesota. And the woman who was targeted, she had a total of 1,700 songs. But the record industry only decided to sue her for 24 songs. And the jury came back and awarded the record companies over $9,000 per song. So about $222,000 is what this woman owed. But she appealed. She said there was something wrong with the jury instructions. And she won the appeal. So she had a second trial. And in that trial, the jury awarded $80,000 per song for $1.9 million. Thankfully, that was reduced to the $222,000, but it might as well be $200 million. I mean, who among us can afford that amount of money? So you say, okay, that's a bad example. Maybe she had bad lawyers. Well, there's a case here in Massachusetts. A BU student was represented by a Harvard Law School professor. And the evidence showed that he had, I believe, 1,100 songs on his computer. And he willfully admitted that. I knew it was illegal. I decided to download it anyway. I didn't care. Well, you can imagine the jury didn't particularly like that defense strategy. So the record companies, again, focused on just 30 songs, not the whole 1,100. And a judgment came back $22,500 per song, a total of $675,000. He appealed to the First Circuit Court, and they upheld the amount. They said that is a reasonable amount under the law. There's a wide range of damages. And the Supreme Court decided not to hear a further appeal, and so the judgment stood. And you say, okay, well, I can't afford to pay $675,000. And so sometimes students ask me, well, what about bankruptcy? That is, can I file bankruptcy to get rid of this debt? And the answer is maybe not. Bankruptcy laws, and we don't need to get into it, but say that if you're engaged in sort of willful and deliberate malicious behavior, the debt you've incurred may not go away. So it's a very difficult to wrap your heads around how much money you may be liable for. And I can tell you that the record industry did that for about 5 years, and they decided that suing their customers maybe was not the best business model, and they've sort of relaxed a little bit. But other industries have stepped in. Movies, there's the Motion Picture Association of America has been targeting students, particularly Disney films. And a more recent trend we've seen on our campus, and I think sort of across the country, is the adult film industry is now attempting to extort money from students. And you think it's bad, when they talked about having boy band music on your computer. Imagine students who come to our office facing these allegations related to these movies. It's a traumatic experience for them. So my piece of advice is really to understand what your presence is online and to understand what the rules are. You may still decide to download music and videos, but understand what's at stake there, that your identity, your ability to hide your identity when you're downloading music, you can't. Your sort of IP address is a great way to track you, and there may be ways to get around it, but if they do find you, they will attempt to get some money out of you, and it's an extraordinary amount of money. So I just ask that you be mindful of that. And this idea of Googling yourself, if you haven't done that, I encourage you to do so, and set up a Google alert so you know every time something is being posted about yourself. It's a very easy step just to keep up to date.
I'd like to thank all of the panelists, and just one quick thing to follow up on. Actually, a couple of the panelists have mentioned this, and we kind of haven't talked about the elephant in the room, and that is sexting, which is prevalent among people in your age group. And so I think if there's one thing that has come out of this today, it is that if you send a picture of yourself to somebody else, to anybody else, to the love of your life, it is not private anymore. It is not yours to control anymore. So if there's one thing you walk away from today, it should be that. Please don't do it, because it will come back to haunt you. We get calls. We have a couple of our prosecutors here who deal with juvenile court and schools. We get calls at least weekly, almost daily, from schools where there are pictures going around the school of students that have voluntarily sent those pictures to someone, And now it's going around the school, and the school is asking for our advice on what to do about that. And parents are calling us and saying, how can we get it down? And from what you've heard today, you may not be able to. We might be able to stop people from spreading it any further. We might be able to punish people who have spread it maliciously. But that picture is out there. So I'm urging you, boys and girls, think about it before you snap that picture. And you've heard from Mike, Snapchat, that picture does not go away. And another thing that we have dealt with here in this county, and you heard about, you heard it from Corey just now, he used the word extortion of students, college students with adult videos. Well, there's a term that has come out in the last few years, and it's called sextortion. And what the person does in that case is they get a hold of a picture that somebody has sent that's floating out there in the internet someplace, and they will contact you. Say, I have your picture, and if you don't send me more, I'm going to put this out to all of your friends, all of your family, all of your email contacts. This is real. This is not a made-up story. This has happened in this jurisdiction. So then what do you do? And sometimes people feel compelled to do what they've been asked to do, and then it just gets worse and worse and worse. There are predators out there, and they can get a hold of these pictures. What you put out there is not private. So please keep that in mind before you click a picture.